This is Philip Bickle of Legal Tyranny. We're going to go over one of the attachments that I included with my opening brief. And right here shows that I filed it in with that particular appeal. This is an entire PDF saved off of the Westlaw website that can be accessed at most any state law library. So State v. Cantabarros. It was the Intermediate Court of Appeals of Hawaii that made this ruling. In fact, one of the judges that was in on this ruling was originally assigned to one of my appeals, but then they consolidated the two separate cases together, and wouldn't you know, he just happened to get moved off. Where are the names of the judges here? I'm missing. Oh, this guy. Right here, Fujisi was on it. Okay, so summary disposition order. Defendant-Appellant Robin Cantabarros appeals from the January 28, 2005 judgment entered by the District Court of the Third Circuit, finding him guilty of the offense of criminal contempt of court in violation of Hawaii Revised Statutes 710-1077. We note sua sponte that contrary to Hawaii Rules of Penal Procedure, Rule 5B1 and 2, the record does not contain a written charge, nor do the transcripts of the arraignment and plea or trial reflect an oral reading of the charge. That's exactly my situation. This one sentence sums up exactly what my situation was for both the traffic criminal and traffic infraction case. And they consolidated and had both of them in one trial on one trial day, so I made all my arguments for both of those things there. Okay, in State v. Gendrish, the Hawaii Supreme Court reviewed the sufficiency of a complaint filed with the district court and concluded, by any fair construction, the complaint is constitutionally insufficient and therefore fatally defective. Not only does it fail to state an offense, but it also fails to meet the requirement that an accused must be informed of the nature and cause of the accusation against him. Territory v. Yoshimura. Alright, so if you recognize a bit of this language here, the insufficiency of the complaint, that sort of stuff, that's because I used the exact same arguments. My situation is identical, and so are probably most traffic court cases. So this one case, now again, when they make these rulings, they can decide to publish or not publish them. And this is how you wind up with very big deal issues, such as the traffic courts failing systemically to provide due process, which is just follow the law. People aren't getting written charges or oral charges. So neither one. They're not being informed. But what do? They make it an unpublished paper. So, I mean, you could get your hands on it, but it's not one of the things that winds up widely circulated. And let's get through the rest of this. It's a short one. The accusation must sufficiently allege all of the elements of the offense charged. Territory v. Henriquez. We have a Ninth Circuit ruling with the same issue here, so that affects not only Hawaii, but everything under the Ninth Circuit. They all recognize that you have to have an allegation of the essential elements. Otherwise, it's a due process violation. This requirement obtains whether an accusation is in the nature of an oral charge, information, indictment, or complaint, and the omission of an essential element of the crime charged is a defect in substance rather than a form. A charge defective in this regard amounts to a failure to state an offense, and a conviction based upon it cannot be sustained. For that would constitute a denial of due process. Gee, this is what my initial appeals, my interlocutory appeals, were alleging. And this same court pretended as if they didn't have jurisdiction over, and they pretended as if I hadn't made an interlocutory appeal dealing with the violation of rights. So perfectly reasonable. It's a well-established collateral attack on proceedings, and they were all supposed to put everything on pause. I'll read out that appeal at some point so you can see what I did. Everything was on the up and up. If I'm going to do this, I'm doing it right. So I've studied their case law on all of these things. Now again, this ruling right here agrees that it would be a denial of due process. That's covered under the 6th Amendment and the 14th Amendment. This requirement may not be waived or dispensed with, and a defect is ground for reversal even when raised for the first time on appeal. Boom, right there. So that's a big issue right there. Oh, shoot. There. So, even when it's raised for the first time on appeal. Alright, lack of jurisdiction or the failure of the indictment or information to charge an offense shall be noticed by the court at any time during the pendency of the proceeding. It follows that the failure to charge cantaberis at all is likewise a denial of due process requiring reversal. Defective oral charge requires reversal of the charged offense. Thereby, it is hereby ordered that the January 28, 2005 judgment entered by the District Court of the Third Circuit is reversed. So, my January 4, 2018 appearance, where Deputy Prosecutor Christopher Schloiter entered oral charges, I called them out. They were defective. One, he wasn't stating them in a common vernacular, and the judge refused to ensure that he was. He told me I needed a lawyer, when you don't need a lawyer for that. They're required to make sure you understand the charges, period. So there's that, and they made sure to correct, to come with well written out charges to read into the record on the day of the trial, but again, they were well over the statute of limitations. So these issues here pretty much constitute the core of my appeal. Alright, that's it for now. If this was useful, like, subscribe, and share the video with people that would benefit from learning.